Hi everyone, in this week's video we are discussing a client question which came in last week, and that is an error in the offer letter specifically, and quite an important one. I've put the incorrect salary on the offer letter and it's much higher than we were proposing to agree following the interview. What can I do about it? The first point to consider is whether or not there is a binding contract in place already. So firstly, if the offer letter has gone out but it hasn't been accepted either by signature or email or even a phone call from the employee, arguably a contract has not been formed at that point, and that means that the offer is capable of withdrawal. Similarly, if the offer letter went out with any conditions attached, so it was subject to satisfactory references or a DBS check being completed, if those haven't been returned, the condition hasn't been met, so the contract hasn't been formed, and again, it can be withdrawn. That's the most simple way of moving that salary back to what was agreed prior to that point. A difficulty arises where a contract has been formed, so the offer letter might have gone out, the employee's accepted it, has obviously not pointed out the error of the salary. What can we do about it in those circumstances? Well, there is possibly the remedy of rectification of a contract. So in circumstances where it was plainly obvious to both parties that that wasn't the salary that was applicable to the role, in the future an employer can make an application to the court to rectify the contract, so to put the parties back in the position where exactly what was expected is performed. So if, for example, there are written notes of a verbal offer having been made, or salary which was put into the job advert or explicitly discussed at interview, and that salary in the offer letter is much different, that's good evidence that there was an acceptance of from both sides that salary in the offer letter was never correct. The difficulty is that that's kind of an after the event application that's made, and it doesn't really give the employer much certainty in the circumstances. The employer will either be pre-employment or in the very early days of employment in these circumstances, and there is greater flexibility by virtue of the 2-year service rule for unfair dismissal. So in those circumstances, I think the first step is just for the employer to seek to agree a variation to the contract and a variation to that salary. If that doesn't work, the employer may need to say, well, we know that the salary is incorrect, but we accept a contract has been formed. What we may have to do is move to terminate that contract and offer to re-engage you on new terms. There's limited scope for an employee to argue that they've been treated unfairly to the extent that they have a viable claim that they can bring against the employer in those circumstances. What I wouldn't do is simply proceed on the basis of the salary that we understood and make those payments without raising it with the employee, because if they raise any grievance as a result, they may perhaps seek to bring an unlawful deduction from wages claim, fairly obscure as well, but what they could try to do is allege that the complaint they made about a breach of their contract, so failure to pay the accurate salary, is a protected disclosure. And if we then took steps to terminate employment, does the employee try and bring a whistleblowing claim? So that just adds risk and fuel to the fire. So there are options available in circumstances where a mistake is made in an offer letter or even in the drafting of an employment contract, especially if that accompanies an offer letter and is made subject to acceptance or other conditions. If you do need any advice on this or any other matter generally, please do get in touch. Visit the website chadwicklawrence.co.uk or email employmenthub@chadlaw.co.uk. Thank you.